Hey everyone, it's Rob Ryder. It's Monday, April 7th, 2014. And over the last week or so, this Civil Rights Act of 1866 has gotten to be very important because when the apparent circuit court judge of a circuit court here in Michigan, the trial court, is using this as the seal. A little bit bigger. Alright. Pay attention to the animal on the right. That's supposed to be a moose. And the moose should be facing the middle. It should look like this. Moose's head going to the middle. With an elk. Okay, and see how the banner is over the wings of the eagle. Well, when you look at this, the banner's way over here on the right hand side. Right, so there's a this is the seal that this P. William O'Grady, who's supposed to be the circuit court judge, used to witness that this guy, Kirk A. Cashman, is a probate judge. As it turns out, they're neither judges, because this is the certificate of determination they use for an election. And there's Kirk right there, and O'Grady, he's on another one, but this one has the judge on it. Want to pay attention to that. From 2012, and this certificate is supposed to be subscribed by the Board of Canvassers of the county. Right, this is a record out of the county record. Easy enough to get. It's called the Certificate of Determination for whatever your last election was. And then they added this other boondoggle thing on here. But the certification says, because this is only certifying this road patrol millage proposal, not the officers. And again, we got the sheriff, we got the county clerk, county treasurer, register of deeds, drain commissioner, surveyor, county commissioners, blah, 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 blah. None of them have been certified as having been elected. Should have something like this on here with the court seal affixed at the seat of the circuit court. Affix the seal of the circuit court. Right? Should be a seal on here, and there isn't. So these folks aren't elected. So not only weren't they elected, and they have an improper oath, they don't have a bond. So here's the one for the sheriff, public official bond, Michigan Municipal Risk Management Authority. This was issued on the 10th of March 2014, yes, just, last month, for somebody who was elected 2 years ago, who still hasn't signed it. Coming out of the office of an administrator controller, where by law it's supposed to be in the office of the county treasurer. Long story short, there is no state. There's nobody holding state office, and we've known this for quite some time now. I mean, to me, this is irrefutable evidence, right? I don't need to look anymore and say, okay, it isn't that there's a problem with the state courts. The problem is there is no state court. It's been usurped by actors. So, they're breaking the law. They're using color of law. And there's something we could do about that. So this goes back to the Civil Rights Act, 1866. An act to protect all persons in the United States in their civil rights and to furnish the means of their vindication. Excellent. There's remedy. Furnish the remedy. And the act relating to habeas corpus and regulating judicial proceedings in certain cases, which was approved March 3rd. So the Civil Rights Act, it by references this other act, the act relating to habeas corpus and regulating judicial proceedings. So you have to have both acts to get a more complete picture, but we're going to look at that. But once that's done, this is going into the United States District Courts, because they are the general trial courts of the United States lowercase federal court system. Both civil and criminal cases are filed in the district court, which is a court of law, court of equity, court of amity. Well, court of equity means court of chancery. In fact, elsewhere in the paperwork it says it's a court of chancery. Right? This court's got 3 jurisdictions. The federal court's got 3 jurisdictions: law, equity, amity. My opinion, we're trying to get to equity, which is the court of chancery, because we want to get an original writ under the Great Seal from the court of chancery. That's what Blackstone says you do, man. That's now you take that into the court of law with your original writ, and what that original writ is going to be is a subpoena to subpoena somebody to come forward and say, by what authority are you doing whatever you're doing? But what this act allowed you to do is file a petition stating the facts and verified by affidavit. It shall then be the duty of the state court to accept the surety and proceed no further in the cause or prosecution. So if you had an ongoing case in a state court, you file a petition stating the facts verified by an affidavit into that court case. That's the way it sounds. And then you're going to you're removing it to the federal court. And so there's much more detail we're going to read. This is just the blurbs, right? And the said circuit court, which is now the district court, shall thereupon proceed to try and determine the facts and the law in such action, right? They're going to treat it like a brand new case, both the facts and the law. And if in any suit hereafter commenced the plaintiff is non-suited or judgment pass against him, the defendant shall recover double cost. So if somebody's brought a case against you to foreclose on you, you put a petition into the court case to say remove it to the local district court, federal, and when they go to prosecute it there, because the court case is already going, you're just saying, hey, they opened the court case, transfer it to the federal. When they look at it, they're going to say, well, there is no plaintiff, right? The plaintiff is non-suited, therefore, pass judgment to the defendant, and he shall recover double cost. For the removal of the cause for trial at the next circuit court of the United States to be holden in the districts where a suit is pending. So back in the day when they first wrote this, and they had district courts. This is all based off the Judiciary Act, basically, of 1790, 1780 something, whatever it is. We'll see it in a minute. 1786, I think it is. So the district courts, number of colonies, about the same number of districts. Actually, there was a couple higher. And then they would take those districts and they split it into 3, and they had 3 circuits then. Each circuit had a certain number of districts, basically meaning a certain number of states under it. And that circuit judge was he would get together with the other circuit judges to make the Supreme Court. And they would go ride the circuit with the district judge within the district that was part of their circuit. And they would make the circuit court. It would be the appeals court to the district court. More on that later. But since the 1960s, routine tasks like resolving discovery disputes can, in the district judge's discretion, be referred to magistrate judges. Okay, so in the 1960s, they got rid of an office called the U.S. Commissioner, and they started the office called the U.S. Magistrate Judge. But they're pretty good about, when they're talking about just it being the U.S. Magistrate Judge, to actually say that in the body of the stuff you're reading. It's like there's this other office called just Magistrate Judge. You got a U.S. Magistrate Judge and you got a Magistrate Judge. Right? So this had referred to magistrate judges. So it doesn't necessarily have to be, in my opinion, the U.S. Magistrate Judge sitting at the court, because what you want to do is, what it looks like we're supposed to do is file a complaint, sworn federal criminal complaint, AO091 form. And I was going to have one of those pulled up, but it's a real simple form. We'll look at it here shortly. 1-page form, but at the bottom, when you get done with what you're doing, you're supposed to take it to a magistrate judge. That's by the federal rules of criminal procedure. Again, we'll look at that more in detail, but that's what you're supposed to do. Now, it's just, who is this magistrate judge? It also says in there, if one isn't reasonably available, then it lists all these other offices that you could go to. One of them being the city of a mayor of a city. And so we took a complaint to a mayor of a city last week, and he said it's out of his jurisdiction. There wasn't anything he could do. Now that city, when you look at it, they don't have a charter. It's like it's really not a city anyways, but it's part of that illusion. So, okay, well then who else could it go to? And that's kind of where this was left last weekend. A lot of reading. So, I think this is what we're supposed to do. So we're still going to do an AO091 form, some kind of criminal complaint. Said magistrate judges are empowered within their respective counties. So this is saying the magistrate judges are in counties to appoint in writing under their hands one or more suitable persons from time to time who shall execute all warrants and other process magistrate judges may issue in lawful performance of their duties. So who are these people within the county that they mean as a magistrate judge that has federal powers? Well, the offices of the U.S. Marshals and Deputy Marshals was created by the first Congress in the Judiciary Act of 1789. Same time they started, they put together the Article 3 courts, they created the office of the Marshals. First in line, first in time. They were law enforcers, but also administrators. They not only enforce the law, they execute the law. Right? They're a minister and they're also a judge. They needed to be adept in accounting procedures and pursuing outlaws, in quelling riots and arranging court sessions. The legacy of the history, avoidance of specialization, even today in the age of experts, U.S. Marshals and their deputies are the general practitioners within the law enforcement community. Now, we've tried to put in criminal complaints for a couple of years now, and they keep telling us you need to go to law enforcement. You need to go to the police, the law enforcement, things like that. Okay, well, a U.S. Marshal is considered law enforcement. He's considered the law enforcement for the federal courts. Marshals were limited to 4-year renewable terms, serving at the pleasure of the president. Well, justices of the peace served 4-year terms. At least here they did. Now, we don't have many more according to our Constitution. And they don't need to be called one to be one. It's just ex officio. It's part of your duties, right? If you're a conservator of the peace as part of your duties, you're a justice of the peace. The marshal, in effect, was the point of contact in frictions between the national government and local communities. The marshal served on extremely important functions. They were the barrier between the civil government and military rule. They were civilian enforcers of the law. So if you want to know who's going to execute your law, it's going to be the marshals. They're going to enforce it. We're the civil authority. We need to go to them and give them our complaint. Obviously nobody is, or we wouldn't have these problems right now, right? So we don't execute the law. We invoke the law. And they go and execute the law. And so this is where the largest republic, because we're in a 4-republic tier system. This was by Thomas Jefferson. Federal government, state, county or county equivalent, township. And so we should be down in this township, the smallest republic, and we're going to be protected by the largest republic, the federal, and they get the guns and the power. There is no state. That's the problem. There's nobody in the state. It's not that the state's against you. It's that there's nobody in the office. And it's just organized crime has taken over and made it look like a government. The marshal, after taking down the names of the militiamen, returned to the courthouse where he promptly called the Secretary of State for permission to raise a posse of 2,000 men, right? That's what a U.S. Marshal can do. He can make a phone call and raise a posse of 2,000 men. In 1795, Congress bestowed on the marshals the same powers in enforcing laws as sheriffs in their districts enjoyed enforcing local laws. So whatever your sheriff can do with the local laws, well, the marshal can do with the federal laws. And how do you say it's a federal crime? Well, you point out a federal statute, 18 U.S.C. 242, color of law, as we'll see. And I am Rob Ryder. My email address is courtofrecord@aol.com. 616-712-6179. If you can, please do donate. The PayPal account name is ashleyritluski@gmail.com, or snail mail to myself, Robert Ritluski, 10955 14 Mile Road, Rockford, Michigan 49341. Okay, I need a minute to set up before we go to the next stage. Okay, here's that AO091 form I was talking about. It's a federal criminal complaint, and I'm not really sure where the complaint part starts. Well, you read CSS criminal complaint under, right? So I might just fill that part out. I, the complainant in this case, right? So somebody with first-hand knowledge, state that the following is true, the best of my knowledge, belief, that on or about the dates of, whatever the date is, in the county of, so in my case, in the county of Kent, in the Western District of Michigan, the defendants violated, and then you're supposed to put down some code, and then the description of the code. This criminal complaint is based on the following facts. Start writing your, what are the facts? Need to add a sheet? Go ahead. Complainant signature, printed name and title. So, I'm going to call myself elector, elector. Robert Allen Ritluski, elector. Sworn to before signed in my presence. So here's the part, right? Who do you give this thing to? Okay, you're going to do this complaint, and when you read the Federal Rules of Criminal Procedure, it doesn't say you need to give it to an attorney or that it needs to come from an attorney. It says it's supposed to be signed by a magistrate judge. Judge's signature, printed name and title, city and state, date. And so, the thought of, okay, well, I got to run down to the federal district court to put this in just doesn't make any sense. But when you read the Federal Rules of Criminal Procedure, it makes it sound like that's where you're supposed to go, is to see that guy. And where is the Federal Rules of Criminal Procedure? Take a quick look, just so we can say we have. Federal Rules of Criminal Procedure, you get down to rule number 3, preliminary proceedings. The complaint is a written statement of the essential facts constituting the offense charged. It must be made under oath before a magistrate judge, or, if none is reasonably available, before a state or local judicial officer. Now, it doesn't define who the magistrate judge is. It does not say United States magistrate judge, and when they're talking about him, they're pretty good about, putting him down there. But this all goes to the different, how they define words. What's a magistrate judge? Means United States magistrate judge as defined by 28 U.S.C. Okay, so in this code for magistrate judges, it defines that it's a United States magistrate judge. So it's a federal judge, a federal magistrate judge. It's just these powers can be given ex officio to another office, and there can be part-time magistrate judges. And so it's very simple to say, well, yeah, you could make the Marshal a part-time magistrate judge just by making him ex officio. And so you would take the complaint that you filled out, this right here, and it's not on this sheet necessarily, but it's 18 U.S.C. 242. So 18 U.S.C. 242, 18 U.S.C. 241. A couple of good statutes to go look at in the criminal code, which has been enacted into positive law, so it is laws of the United States, and yes, you do have to follow them. So do they. No one's ever sworn anything against you, right? You've never actually been in a real court. You're going to a racketeering franchise court. And this is going to show us how we get out of that court into the proper jurisdiction, where an act to protect all persons in the United States in their civil rights and furnish the means of their vindication. Right? So what's a person? I say I'm not a person, I have a person. It's my property. What do you want with it? Right? I'm going to protect my property. They're going to give me the means to do it. So be it enacted by the Senate and the House of Representatives of the United States that all persons born in the United States, that group of people, and not subject to any foreign power. Now, is that two different kinds of people? That all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. Well, I certainly get taxed, and I was born here, so I am a citizen of the United States. And such citizens of every race and color, without regard to previous condition of slavery or involuntary servitude, except as a punishment for the crime whereof the party shall have been duly convicted, so show me that I've been convicted of being a slave or involuntary servitude, shall have the same right in every state and territory in the United States to make and enforce contracts, to sue, be parties, and give evidence to inherit, purchase, lease, sell, hold, convey real and personal property, and to the full and equal benefit of all laws and proceedings for security of persons and their property, as is enjoyed by whitey. Right? White citizens, whatever they are. What the hell's a white citizen? Right? That's a color of law. Just citizens, enjoyed by citizens, period. Okay, same as white citizens. You're supposed to have the same rights no matter where you came from if you meet the general criteria of not being subject to a foreign power, and you were born here. You're going to have the right in everything. Now, I'm sure that it says the same thing even if you weren't born here, but it's just, maybe it's in a different act. I don't know. We're still going to use it, right? Because if you have a driver's license, or have ever had a driver's license, they can consider that citizenship. Excuse me. They can consider that citizenship in the United States. And be it further enacted that any person who, okay, so now this section right here, so this is a law written in 1866, and this section is almost word for word what it's going to say in 18 U.S.C. 242. Any person who, under color of law, statute, ordinance, regulation, or custom, shall subject or cause to be subject any inhabitant of any state or territory to the deprivation of any right secured or protected by this act, or to deter to a different punishment, pains, and penalties on accounts of such person having at any time being held in a condition of slavery or involuntary servitude, except as a punishment for a crime whereof the party shall have been duly convicted, or by reason of his color or race, then the prescribed punishment, white persons shall be deemed guilty of a misdemeanor. If you use color of law, you're guilty of a misdemeanor, shall be punished by fine not exceeding $1,000, or imprisonment not exceeding 1 year, or both, in the discretion of the court. And the magistrate judges can hear cases of misdemeanors. It's further enacted that the district courts of the United States within their respective districts shall have exclusively of courts of the several states cognizant of all crimes and offenses committed against the provisions of this act. Right? It's a federal crime. They're using color of law. There's nobody there in the state. None of those offices exist. It's color of law. You need to put a complaint in, or, as you're going to see, maybe move the case to the federal court by putting in the petition and the affidavit. But we're going to go first to find the magistrate judge and say, hey, there's a crime being committed. And also concurrently with the circuit courts of the United States for all causes civil, criminal, affecting persons. And again, the circuit courts don't exist anymore. That would have been a circuit court judge, or before that a Supreme Court judge, coming to the district and sitting with the district court judge to make the circuit court within that district. Affecting persons who are denied or cannot enforce in the courts or judicial tribunals of the state or locality where there may be any of the rights secured to them by the first section of this act. Right, so if you can't get a remedy in the local courts, you can take it to the district court. And if any suit or prosecution, civil or criminal, has been or shall be commenced in any state court, if you're in a foreclosure, against any such person for any cause whatsoever, got a traffic ticket, or against any officer, civilian or military, other persons for arrest or imprisonment, trespass, wrongs, under color of authority, yada yada yada, you can remove such cause, and the way that you do it is covered in the act called the Act Relating to Habeas Corpus and Regulating Judicial Procedures in Certain Cases, which was approved March 3, 1863. See, we're still in a rebellion, right? All this shit happened back in the Civil War, and they never declared a peace treaty, and they've been writing executive orders ever since. We're in the rebellion they were talking about back then, so all this shit still applies. The jurisdiction of civil and criminal matters hereby conferred on the district and circuit courts shall be exercised and enforced in conformity with the laws of the United States, so as laws suitable to carry the same into effect, and to help us conform the temporal order to the will of the Lord. Beautiful. The laws are on our side. We're just going into courts that don't exist. They got a name. They got a name tag. Right? They're imposters. Punish all offenses against the law. The common law is modified so as not to be inconsistent with the Constitution. Laws of the United States shall extend and govern said courts in trial and disposition of such causes. The district attorneys, marshals, and deputy marshals of the United States, the commissioners appointed by the circuit and territorial courts of the United States with powers of arresting, imprisoning, and bailing offenders against the laws of the United States. And it's these commissioners that they got rid of, I think in 1968 when they put in the magistrate judges. But they took over their powers. That's part of that act for magistrate judges, U.S. magistrate judges. In the act, they're taking over the duties of the commissioners, United States commissioners, the officers and agents of the blah blah blah, and every other officer who may be specially empowered by the United States. Right? So all these people shall be, and thereby they are hereby specially authorized and required at the expense of the United States to institute proceedings against all and every person who shall violate the provisions of this act. You've hired your attorney. It's going to be these people. Put in the complaint. They're going to sue in the name of the United States of America, Title 18, and have them throw the Title 42 equivalent on. There's a Title 42 equivalent for color of law with Title 18. I don't remember what the number is. But they're going to prosecute it. They're both crimes. One's a public crime. It's like, disturbing the peace. Somebody breaks into your store. Well, first of all, somebody disturbed the king's peace. That's the public crime. But they broke into your place and took your property. That's the private crime. It's public and private both. So let the government prosecute it and get you your remedy. Get you your damages. Or get you your property back. That's what the Court of Chancery can do. Sometimes there is no property to get back. Sometimes you're going to have to take a money damage. Okay. Anyways, anybody who violates this act and cause him or them to be arrested and imprisoned or bailed as the case may be, in which case they're going to issue a subpoena, an original writ under the Great Seal from the Court of Chancery, and with a view to affording reasonable protection to all persons in the constitutional rights of equality before the law. So to afford a speedy and convenient means for the arrest and examination of persons charged in the violation of this act. Well, that all that makes it sound like it has to be these commissioners. and such commissioners are hereby authorized and required to exercise and discharge all powers and duties conferred on them by this Act, and the same duties with regard to offenses created by this Act. Okay, so they were supposed to get the ball rolling. And it be further enacted that it shall be the duty of all marshals and deputy marshals to obey and execute all warrants and precepts issued under the provisions of this Act, when to them directed, and should any marshal or deputy marshal refuse to receive such warrant, or to use all proper means diligently to execute the same, he shall be convicted therefore. So I think what they did is they got rid of the commissioners. They gave more power to the marshals. The marshals are going to act as the magistrate judge ex officio within their county and give the warrant to the deputy marshal, somebody he's hired to actually be the marshal, because the marshals are accountants. They're not necessarily busting down the doors. They got deputies for that. Right? They're the administrator. And the better to enable the said commissioners to execute their duties faithfully, efficiently, in conformity with the Constitution of the United States, requirements of this Act, they are hereby authorized and empowered within their counties respectively, to appoint in writing under their hands any one or more suitable persons from time to time to execute all such warrants. Well, that's what the deputy, that's the job of the deputy marshal. He can issue the warrants or execute the warrants, and they would be appointed by the marshal, and other process as may be issued to them in a lawful performance of their respective duties. And the person so appointed to execute any warrant or process as foresaid shall have authority to summon and call to their aid the bystanders or posse comitatus of the proper county, or such portion of the land or naval forces of the United States or militia as may be necessary. As I showed in the beginning, one duty called out a posse of 2,000 people by making a phone call. Called the Secretary of State, I need 2,000 people. Boom. Right? If you want to have the enforcement power, so who's got the enforcement power? The federal government has it. They have the guns. And these dudes working in your county as a magistrate judge / deputy marshal, ex officio, maybe it's the emergency county emergency manager, because when you read his stuff, he can call it the military, and he's sitting in the county. Right? So, but it has something to do with the marshal. So they have they got a main office. Good place to start. To ensure a faithful observance of all clauses of this Constitution, which prohibits slavery in conformity with the provisions of this Act. Right? You want to give the federal government jurisdiction, you got to quote federal laws and tell them what they did against the Constitution. They made you a slave. Because there's nothing happening to you that's lawful. It's all by coercion. And further enacted, any person who shall knowingly or willfully obstruct, hinder, prevent officer, don't stop him, from arresting any person, if you shall harbor or conceal any person. Right? Bad news for you. And it's going to the District Court of the United States. It's further enacted, the district attorney, marshals, their deputies, and the clerks of the said district and territorial court shall be paid. Okay. Persons authorized to execute the provisions to be issued by such commissioners for arrest of offenders. It's just who's the commissioners now. Got rid of them in the 60s when they put in the U.S. Magistrate Judge Act. Whenever the President shall have reason to believe that offenses have been or are likely to be committed against provision of this Act within any judicial district, it shall be lawful for him in his discretion to direct the judge, marshal, district attorney, such district to attend at such place within the district, yada yada yada, and hold court All right. What's this other act? So this is an act relating to habeas corpus and regulating judicial proceedings in certain cases. This is where the remedy is. It's in this act, which is part of the, by reference, part of the Civil Rights Act. Being enacted by the Senate, House, Representatives, United States of America, in Congress assembled, that during the present rebellion, right? So are we still in a rebellion? Yep. The President of the United States, whenever in his judgment the public safety may require it, is authorized to suspend the privilege of writ of habeas corpus in every case throughout the United States. Oh my God. He can suspend. I wonder if he's done that. And wherever the said privilege shall be suspended, as foresaid, no military or other officer shall be compelled, in answer to any writ or habeas corpus, to return the body of any person or persons detained by him by authority of the President. So if the President has said he suspended the privilege of habeas corpus, then the military or other officer isn't compelled to return the body of a person detained by him by the authority of the President. Okay, so if they've suspended habeas corpus and somebody's in jail and he's not being held by the authority of the President, then what's he in jail for? But upon the certificate under oath of the officer having charge of anyone so detained, that such person is detained by him as a prisoner under authority of the President. So where's the fucking certificate that says the guy being held is there under the authority of the President? Because we're under military rules, so the President is setting the rules. Right? Where's the certificate that says you can hold that man? They don't want a writ of habeas corpus. They want you to ask him for the certificate. Make him prove there's a certificate. Go to the U.S. Marshal and say, I don't believe there's a certificate under oath of the officer having charge of anyone so detained that such person is detained by him as a prisoner under the authority of the President. And he certainly wasn't convicted of a crime because nobody signed the sworn complaint. There is no complaint against the defendant. See, here it is. Akima's got a copy of the one against her husband. It's blank as can be. They got an X mark where to put the name for the complainant. Isn't filled out. Warrantless arrest. Well, it wasn't even, again, it's not even an arrest, right? It's a kidnapping being held for ransom, disguised as an arrest, and you putting up bail. Further proceedings under the writ habeas corpus shall be suspended by the judge or court having issued the said writ, so long as suspension by the President remains in force and said rebellion continues. And the rebellion's still going. Now this is where it really gets interesting. And be it further enacted that the Secretary of State and Secretary of War be, and they are hereby directed as soon as may be practicable, to furnish to the judges of the circuit and district courts of the United States and the District of Columbia. Again, the circuit court really doesn't exist. The trial, the circuit court appeals portion went to the Circuit Court of Appeals, and the circuit court's trial jurisdiction went to the district courts. So now it's at the district court. A list of names of all persons, citizens of states in which the admission of the laws has continued, unimpaired in the said federal courts, who are now, or may hereafter, held as prisoners of the United States, by order or authority of the President of the United States, or either of the said secretaries in any fort, arsenal, other place, as state or political prisoners. Is there a chance you're being held as a state or political prisoner? If you are, then the judge of the circuit district court is supposed to have a list with your name on it. Or otherwise than as prisoners of war. The said list to contain the names of all who reside in the respective jurisdictions of said judges, or who may be deemed by the secretaries, or either of them, to have violated any law of the United States in any of the said jurisdictions, and also the date of each arrest. The Secretary of State to furnish a list of such persons who are imprisoned by order and authority of the President, acting through the State Department and the Secretary of War, to list such are imprisoned by order or authority of the President, acting through the Department of War. Now, when you're in prison, you don't have to be in a prison. They have a gaol, G-A-O-L, right? It's a prison where you're just walking around the street, but you're basically under arrest. So did we somehow break a law? It gets better. And in all cases where the grand jury, having attended any said courts having jurisdiction in the said premise, after the passing of this act and after the furnished of the said list, as aforesaid, has terminated its session without finding an indictment or presentation, or other proceeding against any such person, it shall be the duty of the judge of said court forthwith to make an order that such prisoner, desiring a discharge from said imprisonment, be brought before him to be discharged. So somebody put a complaint in against you for breaking some law of the United States in a time of war, and that list was supposed to go to the grand jury, who were supposed to look it over and either issue an indictment or not. And if they didn't issue one, then the judge, when you go to ask him to be discharged, is supposed to discharge you. And every officer of the United States having custody of such prisoner is hereby directed immediately to obey and execute said judge's order. And in case he shall delay or refuse to do so, he shall be subject to an indictment or for a misdemeanor and punished by a fine not less than blah, blah, blah. And the marshals make lists of people. Political prisoners. It's one of their duties. It's wonderful. All right, so somebody put in a charge against us. It never went to the grand jury. There's never been an indictment, but there is a charge. It's an open charge, and we need to have it discharged. And we can have it discharged basically for lack of prosecution. Provided, however, that no person shall be discharged by virtue of this provision of this act until he or she shall have taken an oath of allegiance to the government of the United States. That's how you get your citizenship. You're going to go take your oath of allegiance. And in support of the Constitution thereof, and that he or she will not hereafter in any way encourage or give aid or comfort to present to the present rebellion or the supporters thereof. Right? You're going to agree to the peace treaty. Call it what you will, but basically you're going to take an oath to say, I'm not breaking the laws. I'm not a man of peace. And provided also that the judge or court before whom such person may be brought, before discharging him or her from imprisonment, shall have power on examination of the case, and if the public safety shall require it, shall be required to cause him or her to enter into recognizance, with or without surety, in a sum to be fixed by said judge or court, to keep peace and be of good behavior towards the United States and its citizens, and from time to time, as such times such judge or court may direct, appear before said judge or court to be further dealt with according to the law as circumstances may require. Appear before the proper magistrate. Right? Don't be gone more than 7 years. And it shall be the duty of the district attorney of the United States to attend to such examination before the judge. And be it further enacted that in case any such prisoner shall be under indictment or presentment on any offense against the laws of the United States, and by existing laws, bail or recognizance may be taken for appearance for trial of such person. But there has to be a complaint against you or an indictment against you. It shall be the duty of the said court at once to discharge such person upon bail or recognizance for trial as for said. And in case the said Secretary of State in War shall any person refuse to admit, furnish the said list of persons held as prisoners as for said, yada 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 yada, not good for him. Excuse me. By a petition, okay, I guess I should read the whole thing. After a grand jury shall have terminated its session without finding an indictment or presentation as provided in second section of this act, by a petition alleging the facts aforesaid touching any of the persons so aforesaid imprisoned, supported by oath of such petitioner or any other credible person, obtain and be entitled to have the said judge's order to discharge such prisoner on the same terms and conditions prescribed in the second section of this act. Take an oath. So this is how you get somebody out of jail. This section here, section 3. Section 3 of an act relating to habeas corpus and regulating judicial proceedings in certain cases. If you Google that, you will find this. And when you get to section 3, it's going to tell you how to get somebody out of jail. That in case any of the such prisoner shall be under indictment or presentation for any offense against the laws of the United States, somebody who's in jail for tax evasion, 18 U.S.C. whatever, and by existing laws, bail or recognizance may be taken for appearance for a trial of such person. Right, so you're under indictment. That's right. It shall be the duty of said judge at once to discharge said person upon bail or recognizance for trial as aforesaid. See, there's people being held in jail. They've never really been to court because you've not been before the judicial tribunal. You've only been to the administrative judge. You, they, whoever. Right, so you would get a hold of the marshal. Let's just say it's the marshal. We're trying to get to the right judge and say, hey, you want to put in a petition for your loved one to have your loved one discharged until the trial. Discharge such person upon bail or recognizance for trial as aforesaid. And in case the said Secretary of State or for any reason refuse or remit to furnish said list of persons held as prisoners at the time of the passing of this act, within 20 days thereafter, or such persons thereafter may be arrested within 20 days from the time of arrest, any citizen may, after a grand jury shall have terminated its session without finding an indictment or presentment as provided in the second section of this act, by petition alleging the facts aforesaid. See, when you look at go watch Indictment Shakedown video I did quite some time ago. It's probably pretty much correct. Well, it's correct enough to say, look, there really isn't an indictment against your loved one. So you want a petition alleging the facts touching any of the persons so aforesaid in prison, supported by the oath of such petitioner, obtain and be entitled to have the said judge order to discharge such prisoner. Right, so got to read that some more, but that looks like it's the way you get somebody out of jail. And the way we find out is we go and talk to these people. Right, when we find out who it is, they're not going to say, I can't give you legal advice. That's what they're there for. And be it further enacted that any order of the President or under his authority made at any time during the existence of the present rebellion, which has been going on since the 1860s, shall be a defense in all courts to any action or prosecution, blah, 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 or under color of law, and such defense may be made in special plea or under general issue. So there could be presidential administrative orders, executive orders, that we could be using to our as a defense in court. And be it further enacted that suit or prosecution, civil or criminal, has been or shall be commenced in any state court, if you're in foreclosure, right, against any officer, trespass or wrongs. They're saying you committed a tort, or you admitted to do something, an error or an omission. The defendant shall, at time of entering his appearance in such court. So this word read before, by virtue or under color of any authority. Well, that's what they're doing because nobody's been elected to the office, so it's all color of. You can remove the case to the district court. Or such appearance shall have been entered before passage of this act. File a petition stating the facts for the removal of the cause for the trial in next circuit court in the United States to be held in the district court. The suit is pending. Offer good and sufficient surety for his filing in such court on the first day of its session copies of such process or other proceedings against him. So we're going to take a copy of our stuff into their court and say, this is going on in the state and I want to remove it to federal court. It shall then be the duty of the state court to accept the surety, right? So if the federal court accepts it, the state court doesn't have a choice. And the bail that shall have been originally taken shall be discharged, and such copies being filed as for said and such. So if you're paying bail now in the state and you move it to the federal court and the federal takes it, whatever they're happy with, it sounds like here the state has to give you back your bond. Got to be discharged. Cause shall proceed therein in the same manner as if it had been brought in the said court by original process, right? So it's going to go to the federal court just like it was starting there to begin with. And any attachment of goods of the state of the defendant by the original process shall hold the goods or estate so attached to answer the final judgment in the same manner as any of the laws of such state they would have been holden to answer final judgment had it been rendered in the court in which the suit prosecution was commenced. And they never give a final judgment. They give summary judgments. There is no final judgment. We're trying to get a final judgment. Once and for all, settle the matter. Well, that can happen in this federal court. And it shall be lawful in any such action or prosecution which may be now pending or hereafter commenced before any state court whatever for any cause aforesaid after final judgment. This is after final judgment from the state court, for either party to remove and transfer by appeal such case during the sessions from such court to the next circuit court of the United States to be held in the district in which such appeal shall be taken in manner aforesaid. You can remove any cause from a state court to the federal circuit court. Because it sounds like they're talking about the appeal process. And the appeal jurisdiction of the circuit court when this was written went to the appeals court of the 6th Circuit Court. But the trial court section went to the district court. I say we take it to the guy playing the magistrate judge / United States Marshal or his deputy and let them figure it out. We just go point the crime out. Right? If you can get them convicted under Title 18, then if you got a Title 42 private claim because they've taken your property, well, you've already got the conviction. Right? You already have the evidence they were guilty, and now you're looking for the damages. It would seem to me they can just do all that at one time. And it shall be the duty of the person taking such appeal to produce. So the person taking such appeal. So to me, it sounds like the clerk of the court, of the state court. I'm going to give you my appeal. Right? And they need to produce and file in the said circuit court attested copies of the process proceedings and judgments in such cause. They need to provide the evidence to the federal court of their crime, attested to. That's a beautiful thing. How do we make that happen? And it shall also be competent for either party within 6 months after rendition of a subject by writ of error or other process to remove the same to the circuit court of the United States of the district in which the judgment shall have been rendered, and the said circuit court shall thereupon proceed to try and determine the facts and law in such action. They're going to look at the whole case over again, not just procedural error or something like that. It's the facts and law. And the facts is they broke the law because there is no sworn complaint. The plaintiff is a fictitious entity. They didn't sign the contract. And. It's fraud and swindles, 18 U.S.C. 1341. Pretty much covers everything. And they did it using color of law, 18 U.S.C. 242. And so you want to put in a claim under 42 U.S.C. whatever number it is for color of law action to get your property back and leave it up to the court to give you damages. Right? Personally, I think when we fill this out, if we want to make this go, this criminal complaint, this is the AL091 form, if we want to make it go into Chancery, then part of your complaint, in a complaint into Chancery, is to list what you want to have for a remedy. What is it you want the court to do? Right? Here's what happened. Here's what I want the court to do. Because it can also be called a complaint and go into a court of amnesty. And I need to look to see if when you put it into amnesty, if you're actually asking for a remedy. But I don't think you are. I think that's the difference between a court of Chancery and any other court. Here's the complaint, here's the remedy I'm asking for, and it's not just money. You want to have property back, you want to have a temporary restraining order, you want to have all these different things other than a money damage, which is what common law can give you. They can give you money. That's all they can give you. Okay. And the state court from which such civil or criminal may be removed, transferred to aforesaid upon the parties giving good and sufficient security for the prosecution thereof. In other words, you're going to give them whatever money they need to open a court case. And of course, you don't need to give it to them. You can say, okay, don't pay for anything. Right? And have you do an indigent form or whatever it is, right? You give them an order. So I'm not paying, right? I'm pointing out a crime. You're going to prosecute. It's already said it in here someplace that they have to do it at their cost, and you go find that section and see if it's got a law that goes with it, and you take it in and show them, according to this law, you need to prosecute this. It's what the law says. I just need to point it out to you. Right? So we're going to go load it up with 3 or 4 different statutes and calmly point it out to whatever magistrate judge we can find, whatever other hat he's wearing. Provided, however, that if a party aforesaid shall fail duly to enter and remove the transfer as aforesaid in the Circuit Court of the United States agreeable to this act, the state court by which judgment shall have been rendered and from which transfer removal shall have been made shall be authorized on motion for that purpose to issue execution and to carry in effect any judgment. So if you don't ask to have this done, the state court can go ahead and finish their deal and take your property. You have to ask for it. If you don't, you consent. It's the way they wrote the law. And provided also that no such appeal or writ of error shall be allowed in any criminal action or prosecution where a final judgment shall have been rendered in favor of the defendant or respondent by the state court. And if any such suit who after commenced by plaintiff is non-suited or judgment pass against him, the defendant shall recover double the cost. Right? You brought fraud upon the court. That's all they're doing, 3 times. If you get double the cost, that means you get your cost and a cost again, or your cost and a double cost, making it a triple cost. Right? Which one is it? I don't know. Let's go find out. Be enacted. No suit or prosecution, civilian or criminal, shall be maintained for any arrest or imprisonment made or otherwise or trespass, wrongs committed, act omitted at any time during the present rebellion by virtue or under color of any authority derived from the exercise by or President of the United States or by or under any act of Congress. And they're just using color of law against us. It looks like it's lawful, but it isn't. That didn't really mean anything. So this was about these commissioners. Ooh. All right, so here it is, Title 42, 1989, United States Magistrate Judges, Appointment of Persons to Execute Warrants, Posse Comitatus. The District Court of the United States and the District Courts of the Territories from time to time shall increase the number of United States Magistrate Judges so as to afford a speedy and convenient means for the arrest and examination of persons charged with the crimes referred to. And the Magistrate Judge shall authorize and require exercise all powers, duties conferred upon them. The said Magistrate Judges are empowered within their respective counties to appoint in writing under their hand one or more suitable persons from time to time who shall execute all such warrants or other process as a magistrate judge may issue in lawful performance of their duties. Okay. So the magistrate judge is somebody who can appoint somebody else to execute a warrant, and that's what a marshal can do. He can appoint somebody to execute the warrant. He must be ex officio a magistrate judge. But now this guy is in your county. It's not like we're talking the marshal that you're going to find on the website for your Western District. He's the chief marshal. He's the chief of all the marshals, and there's a marshal in every county, and he has the same powers as the sheriff does in federal law as the sheriff does in local law. Whatever the sheriff can do, he can do. He can just do it better. Okay, prosecution of violation of certain laws. United States attorneys, marshals, deputy marshals, United States magistrate judges, appointed by district and territorial courts with the power to arrest, imprison, or bail offenders, and every other officer who is especially empowered by the President, are authorized and required at the expense of the United States to institute prosecutions against all persons violating any of the provisions of Section 1990 of this title, or any Section 5506 to basically 5532 of the revised statutes. That's your elective franchise, most important franchise you have. Marshals to obey precepts refusing to receive or execute process. Every marshal, deputy marshal shall obey and execute all warrants or other process when directed to him. Right, so if you want to execute process, well, what's part of the process? A complaint is part of the process. If I take a complaint to a marshal, he's got to execute it. If I'm pointing out, hey, they broke a federal law and here's some evidence, he's got to execute the frickin' complaint and issue a warrant or a subpoena to have whomever come in and answer for whatever it is. United States magistrate judges appointment. District courts, United States, from time to time shall increase the number of United States magistrate judges. Right, so they have these part-time magistrate judges, and such magistrate judge are authorized and required to exercise all powers and duties conferred on them herein, and required such offense in like manner as blah 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 blah. Okay, section was formerly classified something in the Section 50 of Title 8, Aliens and Nationality. Change of name. That's interesting. I got to go back and see what that was about. But I highlighted it because it talks about this being part of something else that had to do with change of name. And somehow our name was changed, right? In one jurisdiction, I'm Robert Allen Ritlewski. In another jurisdiction, I'm Ritlewski, Robert Allen. Well, that Ritlewski, Robert Allen is the jurisdiction that we keep going into these fictitious courts for. And that's not my name. Right? If anything, it's a fictitious name. I'm going to say it's my property, but it isn't my name. I don't go by that. So let's change the name and give me my property that you've stuck under this other name to hide it from me. Previously, magistrate substituted for commissioners. Okay. District court substituted for circuit courts. Yep. And anyways, this talked about, the reason for all this is in this law, it talks about these people's duties in these particular sections of code. And these particular sections of code have to do with your elective franchise. And so it has to do with your right to vote. And your right to vote means this: you're either going to vote to be in the republic or vote to be in the democracy. Right now they got you in the democracy and they won't let you go vote to go to the republic. And that is, where is that? Right in here. So that sections they're talking about are in the revised statutes of the United States, which is the first official codification of the positive laws of the United States. And that section is Section 7, Crimes Against Elective Franchise, and civil rights of citizens. Now, since then, it's been codified into like 18 U.S.C., 42 U.S.C. Those are considered positive laws. So now we're not using section numbers, we're using 18 U.S.C. something or other. But when you go to try to follow this through, it's going to say that these were repealed. This particular chapter, right? These things are repealed. You don't find them in the 18 U.S.C.s. But it isn't what matters, because 42 U.S.C. Code says whatever was written in those, even though it's just by reference, it's putting it in. It's not spelling it out. It's by reference. If any of these sections have been violated, it's the duty of the United States Attorney, Marshal, Deputy Marshal, United States Magistrate Judges to enforce the fucking law. And so this is what they've done. And why? 5506. Every person who, by any unlawful means, hinders, delays, prevents, or obstructs, or combines in confederates with others, that'd be a conspiracy, to hinder, delay, prevent, obstruct any citizen from doing any act required to be done to qualify him to vote. And they won't let you do an affidavit to register to be a qualified elector within your precinct, within the smallest republic, which is where you're supposed to claim your domicile. And the larger republic will protect the smaller republic, because that's what they do by international law. It's just we're not in the republic. We're in the frickin' democracy. And we need to vote to get out. And to do that, you do it by showing your intent, which is to do an affidavit to say, I'm claiming this is my domicile, by registering to be an elector within your precinct. And then you get put in a different book, right? You get put in the book of life. You just went to the republic and out of the democracy. So anybody who prevents any citizen from doing any act required to be done to qualify him to vote, or from voting in any election in any state, territory, district, county, city, parish, township, or school district, municipality, or other territorial subdivision shall be fined not less than $500 or imprisoned not less than 1 month for more than 1 year, or punished both. It's against the law to not allow you to register to vote. And they need to go enforce these laws. So we go to them and say they're not allowing us to fill out the affidavit of registration. And show them in the law where it says what it's supposed to say. Because when you go down there, they'll hand you something and say, well, when you say I'd like to register as an elector, well, I can register you to vote. Well, no, I want to register as an elector. I want to do an affidavit of registration. Well, we have this application to vote. Okay? Or they may even call it an affidavit, but when you know that it doesn't matter what anybody calls Jack. What matters is what's the definition. And an affidavit is an oath rendered in writing, sworn to before the proper officer. So if you didn't take an oath, it's not an affidavit. And they won't let you do that as part of registering to vote. And as soon as you do, you'll put yourself in the republic and out of the democracy, and you are the civil authority within your democracy or within your republic. And the big bag boogeyman, who is everybody from FEMA to Homeland Security to the magistrate judge to the district, they're not your enemy. They're guarding the line between you and them. And, you know, we got a lot more to cover, but I just wanted to, I'm going to stop here on this, that this is the idea. Next video, we're going to look at the Marshal closer, show you what it says about the Marshal, and a couple other things. So, excellent. We'll carry on from here. See ya.